A few weeks ago, we spoke with an American military officer who reported to us about a speech that he had heard an American general give to a group of officers in training. The speech had said, "Never forget one thing. We are only in Afghanistan for one reason, and that's revenge." This is completely different from official U.S. foreign policy, official U.S. military policy, but I think that it has a great deal of psychological reality. All of us who lived through 9/11 and the months immediately after will remember that the sequence of events was, after the attacks and the shock, a demand that Afghanistan hand over Osama bin Laden, and after it was rejected, a quickly organized invasion, which was justified by the forward-looking justification of the need to break up al-Qaeda training camps. But it felt as though that wasn't the only reason. The desire to reach out and kill somebody, the desire for revenge was extremely thick in the atmosphere in the United States. Now, in the involvements that I've had in the torture debate in the United States for the last few years, I've been startled at how much support for torture there is among Americans, and become convinced that even though torture is always justified in a forward-looking way, it's necessary to get information in order to safeguard us, that really a lot of the debate is, a lot of the sentiment is powered by this thought that these are bad people and they have it coming and they deserve it. I should just like to point out that the official CIA protocols for the treatment of so-called high-value detainees were to give the detainee one chance to provide actionable intelligence, which meant either the name of another high-value detainee or something that could be immediately translated into a strike, and then the torture would begin. And it seems to me that it's impossible to explain this in anything other than a desire for revenge. Now, these are part of my background thoughts for writing this paper, which is a paper about an ancient theory of the just cause of war, and that is, can everybody hear me fine? Okay. And that is what I call the punishment theory of just cause, which is just what it sounds like, that the just cause of war is to punish the bad guys. Just war theory, the punishment theory goes all the way back to St. Augustine. Now, Augustine, I think, actually was not a consistent thinker about just cause of war, and I think there were actually at least 3 different theories of just cause in Augustine, some better and some worse. But the one that I want to focus on is from his Questions on the Heptateuch. This is an extremely influential passage in Augustine. It goes like this: as a rule, just wars are defined as those which avenge injuries. If some nation or state against whom one is waging war has neglected to punish a wrong committed by its citizens, or to return something that was wrongfully taken. So you can punish wrongs that were done by another state, or the wrong that was done when a state failed to make amends for the wrongs that its own citizens did. And of course here, Afghanistan failing to turn over Osama bin Laden comes to mind as a contemporary example of this. Now, this passage turned out to have legs. It was extremely influential. It was quoted explicitly by Gratian, who's the great codifier of canon law, in the Decretum. Aquinas cites that specific passage that I just read in his own discussion of just cause, where he then says a just cause is required, namely that those who are attacked should be attacked because they deserve it on account of some fault. Vittoria quotes Aquinas, the passage that I just read, to say that the cause of the just war is to redress and avenge an offense, as said above in the passage quoted from St. Thomas. And maybe the most elaborate version of this, and one that I want to focus on because the others don't really have an argument, but this one has an argument, is from the 15th century canon jurist Cardinal Cajetan, who I've got to say I'm not a great scholar of Cajetan, and the first time that I heard his name in graduate school, which was on a seminar on Descartes, I for weeks thought that it was a declension of cogito. So Cajetan also quotes Aquinas and then says that the prosecutor of the just war functions as a judge of criminal proceedings. The Commonwealth, in defense of its members and itself, is allowed not only to repel force with moderate force, but also to exact revenge for injuries to itself or its members, not only against its subjects, but also against foreigners. And then the argument that he gives is that if the state had no authority to, quote, avenge itself and its citizens by fighting against the foreign oppressor, then unpunished evils would naturally remain. And he said that that would mean that natural reason had been violated and that the Commonwealth was not a perfect Commonwealth. Now, I'd like to just step out of the historical reconstruction for a moment and say that one might think that there are two other responses, one of which is that this is a call for something like international criminal law. And that's not one that I want to resist. The other is that perhaps there should simply be unavenged wrongs in the world. And that's actually my title, War Without Vindication. Now, Cajetan goes on and says not only can you punish wars against yourself and your citizens, you can also punish wars against your allies, injuries against your allies. And he advocates collective punishment. He says that, in fact, all of the citizens of the wronging state are presumed to share in its wrongdoing, and so the punishment can be visited against all of them. Now, there are similar passages about the punishment theory in Calvin and Luther, so it's not simply a Catholic theory. In Grotius and in Vattel, who gives what he calls vindicative war, that's Cajetan's term as well, as one of the three just causes of war. Now, obviously, that is not where we are now. So just to fast forward to the United Nations Charter, now, Article 2 of the United Nations Charter forbids the use of force or the threat of force against state sovereignty, with just one exception in Article 51, and that is self-defense. And I take it that that theory of just cause is very similar to the theory of just cause in Michael Walzer's Just and Unjust Wars. So one question that's interesting is what happened between then and now. Self-defense is also a theory that goes all the way back. But self-defense, as opposed to the punishment theory, is, I think, somewhat more recent. In the 18th century jurist Martins, you find the sense, I mean, he doesn't say it in quite this way, but that self-defense is the only just cause. The United States Constitution empowers the United States Congress to create an army for purposes of common defense. And it doesn't say to fight the states' wars, it says for common defense. But I think that the first explicit critic of the punishment theory is Kant, who in Perpetual Peace asserts that war of punishment between states is inconceivable, since there can be no relationship of superior to inferior among them. And I'd like to focus on that argument a bit. There's a old Roman legal maxim, parim param non habet imperium, equals have no powers over equals. It's still quoted by international courts, for example, the European Court of Human Rights, fairly recently, to explain why, to sovereign immunity, why one state can't implead the government of another state in its own domestic courts. But it's pretty much Kant's argument. Vattel, I should say, has the same argument. He's somebody I won't talk about now, but he's interesting because I think he is the proto-McMahon. He, in the sense that he has a deep morality of war, what he calls the necessary law of war, in which only one side can be just, and in which everybody bears the guilt of an unjust war, and the superficial surface law of war, what he calls the voluntary law, in which you presume that all sides are just because equals have no dominion over equals. Now, the first version of that argument that I want to say something about would be simply to read this the way that lawyers do, as an argument about authority or jurisdiction. States have no authority over other states, and therefore they have no authority to punish other states. It seems to me that the reason that the punishment theory gets replaced by a self-defense theory, historically probably because the nation-state system, the system of state sovereignty, unrestricted state sovereignty, solidifies during the period of time between Cajetan and Kant. This raises a problem for those of us who think that state sovereignty should not be unrestricted. So let me just call this, for short, the post-World War II theory. Think of Nuremberg as the proposition that even state actions, criminal actions that are lawful under the domestic law of the state can still be crimes, international crimes, punishable by the court. The theory that Kofi Annan developed in his many speeches and writings during the 1990s about how state sovereignty had to be state sovereignty consistent with human rights. Now, if you believe that, then the par in parum non habet imperium justification for abandoning, for criticizing the punishment theory becomes weaker. And it almost seems as though the door is open for the punishment theory to return. There's another version, though, of Kant's argument that I think survives the post-World War II revolution in thinking about state sovereignty. This is also an old view. You can find it in Suarez, who puts it this way: the same party in one and the same case, so this is his objection to the punishment theory, the same party in one and the same case is both plaintiff and judge, a situation which is contrary to natural law. So now the argument has shifted terrain, and it's not that one state has no authority over another state. It's that if you allow one state to punish another state, and I might say the same thing would be true in this argument for states punishing non-state actors, then you have a tremendous possibility of biased judgment. Because the same party is both the plaintiff and the judge. The injured party is deciding the gravity of the injury and administering the punishment, and the risk that it's going to over-punish or wrongfully punish or punish things that shouldn't be punished is too great. It's contrary, Suarez says, to natural law. I won't make a natural law argument, but it seems to me that the argument makes a great deal of sense even outside of the natural law boundaries. Now, that's going to be the first criticism that I'd like to raise against the punishment theory, and my aim, as you have guessed, is to criticize the punishment theory. I think it will help at this point, though, to draw some distinctions, because the concept of punishment is one that we haven't really looked at carefully. In the longer paper that this comes from, I try to distinguish four things: revenge, retribution, reprisals, and restitution. By restitution, this is a very ancient idea also, using military force to recover stolen property or to exact compensation for injuries. Because of limited time, I won't say anything about reprisals or restitution. We could talk about those later if you wish. But I would like to distinguish strongly between revenge and retribution. Because revenge, as I understand it, is a completely non-cognitive response. It's an emotional response. Jean Hampton, in her wonderful article on the retributive idea from which much of my discussion derives, just talks about it as the primitive bite-back response that you can find throughout the animal, even the plant kingdom, in the case of poison ivy, for example. And it's simple. You hurt me, I hate you, I'll get you. That's revenge. Now, the one thing that's wrong with talking about bite-back is it suggests that it's an instantaneous response that will fade as soon as reason reasserts itself. It doesn't have to be. When Homer says that vengeful anger is sweeter than slow dripping honey, I think that slow dripping matters as much as the sweetness of revenge. Think of Iago, who's taking revenge for Othello having promoted Cassio over him. Long, careful, calculated revenge. Nevertheless, it still is the bite-back response. There's another complication besides the possible slowness of revenge, and that I'll just mention is the notion of a vendetta or an honor culture in which you might be required to take revenge simply because that's the norm within the culture. Where, and here I think of a culture in which an affront against the family means that you are dishonored if you don't murder the person who affronted, rather than dishonored if you do. Very close in some ways to military culture, where even though soldiers may realize intellectually that the other side that has killed and maimed their buddies has a legal and under the War Convention moral right to do so, still the bite-back response is very strong, and the possibility of taking revenge is very powerful. I think this is completely different from retributive justice, which I view as a cognitive response to a wrongdoing. And I think that just for the sake of brevity, I don't want to get deeply into this. Let's just say that it involves a moral judgment that somebody has improperly treated themselves as high or their victim as low. Either they're the kind of person who gets to do this stuff to you, or you're the kind of low person that other people get to do this to, or both. And the retributive response is simply to administer what Hampton calls an expressive defeat on the wrongdoer in order to reassert the moral truth. And what I want to emphasize here is not the details of the account, but 2 points. The first of which is that it's meant to be a response that involves moral judgments. It doesn't mean that it can't have an emotional basis, but it's not fundamentally powered by the emotional basis. It's powered by the moral judgment. Second, that retribution requires a judgment of proportionality. And even in the discussion of the punishment theory of just war, that proposition goes back at least as far as a generation after Vittoria, where Molina asserted the need for proportionality in Vindicative war. Now, the problem with revenge is that revenge has no principle of proportionality in it. It involves a double distortion. First of all, the amount of hurt that I might experience might not be proportional to the wrong that you've done that causes me the hurt. And second, the amount of rage that I might feel because of my hurt doesn't have to be proportional to the level of hurt that I experience. And in fact, revenge has no inner stopping point other than the complete discharge, the draining of the vengeance, the draining of the rage against its object. So it has no built-in principle of proportionality, and punishment has to be proportional. Now, this creates, I think, an incredible problem for the punishment theory of just war, because so often the punishment will, of necessity, be disproportionate to the offense. I don't claim originality for this argument either. It's an argument of Pufendorf's. Military necessity means that you fight to the point of victory. The point of victory has no necessary connection with the proportionality of punishment to wrongdoing. I want to say that the punishment theory of just war or just cause is wrong in part because it will involve a use of force that is almost certainly bound to be disproportionate to the offense that's being punished. So we now have two arguments against the punishment theory. The first is that there's no impartial judgment, which retribution calls for, when the plaintiff is the judge. And second, that there won't be a proportionality. There are two other problems as well. The punishment is collective. Now, for some people, those who believe in a completely individualistic theory of punishment, that is already itself an insuperable obstacle. I actually am a believer in notions of collective responsibility. The problem is a distributive one, and that is that within a collective in which a lot of the members bear responsibility for the wrong that's being done by their state, their armies, their government, the punishment is distributed completely arbitrarily. That is, the most responsible people aren't necessarily the people that are suffering the most severe punishment. And the final problem is something that I'll simply call the modality problem. Warfare is the wrong mode for delivering punishment. If we think of punishment in what I think of as the contemporary modern notion of what is an acceptable and unacceptable mode of punishment. Nowadays, we think that only two forms of punishment are acceptable, one of them being physical confinement, imprisonment, the other being fines and restitution. What we don't accept, occasional cases of the death penalty for very severe crimes, but we don't accept the death penalty, even those who support capital punishment, for all levels of support for crimes. We don't accept maiming. We don't accept the destruction of one's children as punishment for wrongdoing. We don't accept the destruction of all of one's personal possessions as punishment for wrongdoing. But warfare can only deliver punishment in the form of those unacceptable modalities. So those are in brief the four objections that I want to raise to the punishment theory of just war. And just once again to recapitulate, the lack of partiality, the disproportionality, the distribution problem, that the wrong people within the collective get the wrong punishments, and finally the modality, that warfare delivers punishment in a form that what I will, begging a lot of tendentious questions, call civilized society does not accept as modes of punishment. Now, to conclude, what I'd like to do is to talk about some contemporary active problems in asymmetric war in which I think the punishment theory of just cause is kind of rearing its ugly head once again. The first is something that's come up a couple of times during our discussion, and that is a currently lively debate in wars against militants and terrorists about who counts as a direct participant in hostilities. This is something of a term of art. It comes from the Geneva Conventions. A direct participant in hostilities, a DPH, is somebody who is a civilian who's lost their privilege against being targeted. Okay. And there's a lively legal debate in which the players have been, first, the Israeli Supreme Court in its 2006 targeted killings decision. Second, the International Committee and the Red Cross, which put out a report on the criteria of DPH last year. Very controversial within the Red Cross. There were a number of dissenters who thought that it was too hawkish. And finally, the United States government, which this is the one that I'd like to focus on. Last year, the U.S. Congress changed the Military Commissions Act and incorporated a definition of an unprivileged belligerent. So this is somebody who can be targeted, and it defined an unprivileged belligerent in terms of a criminal conspiracy statute. It said that an unprivileged belligerent is somebody who materially supports hostilities against the United States, cross-referencing a criminal statute called material support for terrorism, in which virtually anything that you do, if you give a militant a cell phone, you've materially supported terrorism. If you give the militant legal advice, you can arguably be said to have materially supported terrorism. If you give the militant even one night's housing in your own home, you've materially supported terrorism. And all of those are now under U.S. law unprivileged belligerents. Now, my diagnosis of this is that we've taken a category that was deliberately designed to cover a crime and guilt, in which all of the proportionality considerations will appear in sentencing decisions and allows for the distributive and modality problem to be solved, and changed it into a criterion for targeting people in warfare. This is one way in which the punishment theory of just cause once again rears its ugly head. Now, once you've defined a lot of civilian supporters of militants or terrorists as being on the guilty side, as being something like direct participants in hostilities, that also completely changes proportionality, because in collateral damage to civilian targets. And the reason is that for proportionality, you're considering a ratio of military targets that can be targeted to civilians who can't directly be targeted. You're reducing the number of civilians, reducing the denominator, and simultaneously increasing the numerator, so that suddenly acts of violence that might not have survived proportionality before you've expanded this notion of the guilty to include large portions of civilian supporters isn't disproportionate any longer. Now, here, I think that the reaction in the popular imagination is roughly, screw them, they had it coming. They are supporting the bad guys. Because they're supporting the bad guys, they simply don't deserve that kind of regard. And that takes me to the third current manifestation of the punishment theory that I want to talk about. This is the controversy over this one I don't think is mirrored in the law the way that the other two are, over how much risk soldiers have to take in order to minimize civilian casualties. This is the debate with Michael Walzer and Avishai Margalit on one side and Kasher and Yadlin on the other side. And here I take it that the position that Kasher and Yadlin defend, this is not in so many terms, is that we simply don't owe the same kind of thing to our civilians and their civilians. And I think that that intuition that, as I've heard one person put it, there are no such things as generic civilians. There are more guilty civilians, theirs, who are bent on our destruction, versus our civilians who deserve our protection. I think is a manifestation of the punishment theory once again. So at this point, I should say that the paper that I'm drawing this from is not complete in either sense. I haven't finished writing it, and I also haven't thought it through to my satisfaction. This is very much a work in progress. I'd like to just stop here and throw it open for discussion.